The U.S. Supreme Court denying a motion for an emergency injunction in the case Beavis versus Naperville, where a gun store owner was suing the city of Naperville, amending that complaint to sue the state of Illinois. Getting a ruling out of the Northern District of Illinois against the plaintiffs and for the city and state, and then taking the case to the appeals court, seeking an emergency injunction, that being denied, and then taking it to the U.S. Supreme Court for an emergency injunction while the case is pending. And yesterday, that was denied. Good morning, Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. Let's get right on into this. We have, of course, the U.S. Supreme Court docket, which shows that May 1st, the National Association for Gun Rights and Beavis, they sued the city of Naperville and Illinois, went all the way up to the U.S. Supreme Court on May 1st, where they filed for that emergency injunction. And you have all the filings back and forth, including from the states and from Naperville. And then, if you recall, you had the case in the Seventh Circuit Court of Appeals where they looked to consolidate all of those cases and made that order in the Seventh Circuit to wrap in the Naperville case with the Herrera case out of Cook County in Chicago, and then also wrapping in the Southern District of Illinois federal cases. And on Friday, that happened last week, and you have a letter that the state of Illinois sent to the U.S. Supreme Court Justice Amy Coney Barrett talking about the expedited briefing schedule for those pending cases in the Seventh Circuit Court of Appeals. Essentially, right after the order was made, the states wrote this letter to the U.S. Supreme Court and said, hey, recognize that this is an expedited appeal going on in the Seventh Circuit Court of Appeals. Well, everyone was holding their breath Monday for a possible ruling from the U.S. Supreme Court as to what's going to happen. Are they going to issue that emergency injunction, or are they going to deny that emergency injunction? And that order didn't come out Monday. It came out through a miscellaneous order on Wednesday, yesterday. And here's the one-sentence ruling. The application for writ of injunction pending appeal presented to Justice Barrett and by her referred to the court is denied. Now, when we talked with Robert Beavis of Law Weapons Supplies out of Naperville last week, he talked about what ultimately it would mean if they did indeed deny this request, this emergency request. And here is Robert Beavis talking with us from last week.
And we would be back in front of the district court and the appellate court trying to, as a group or as a whole for Second Amendment, trying to get back to the U.S. Supreme Court. It could be a year later. By that time, you've got all the laws are in effect with the registration and everything. So it's very important that we, continue to fight as law weapons. And
so there's a lot of questions as to what happens now, and will there be any outcome in this case if indeed this is going to be held up in the Seventh Circuit. Now, the expedited appeal and the consolidated cases, those are all rushing through, and you've got a hearing that's actually going to be taking place in this case late June. So just a handful of weeks here, and we'll have oral arguments in the Seventh Circuit Court of Appeals challenging Illinois' gun ban and local gun bans as well. But what's the strategy here from the state? How are they moving forward with all of this? Earlier this week, after the Illinois Supreme Court hearing, Attorney General Kwame Raoul stopped to talk to media, and I asked him about, hey, what's the strategy you guys are looking to employ here with the cases now in the Seventh Circuit Court of Appeals?
With regards to the federal cases, we're going to litigate that in federal court, not before microphones.
So you don't want to
No, he doesn't want to provide any kind of strategy of sorts. But you've got this ongoing question about, will this all be taken care of before the January 1st, 2024 deadline for people to register their firearms if they had them before January 10th of 2023. That's part of the law. If the law is upheld, then that's going to be a criminal penalty if you do not register your grandfathered semi-automatic rifles, shotguns, or pistols before January 1st, 2024. And it could come with some pretty steep penalties, including you losing your rights to own a firearm. So obviously there's a lot of things moving here, and you've got the National Shooting Sports Foundation, their executive director, Hannah Hill, posting a video yesterday with a little bit more in depth as to how they're thinking about this case. Again, here's Hannah Hill.
So the Seventh Circuit gambled on the fact that if they put us on the rocket docket, as our lawyer called it, the Supreme Court would wait to step in. And that appears to be exactly what has happened. If the Supreme Court had granted emergency relief to us now, that would only have been temporary. It would not be on the merits. It would not be binding on the case itself. That means that the Seventh Circuit could still rule against us, and the Supreme Court would then have to step in a second time. Now, this way, the Supreme Court's going to wait to let the Seventh Circuit rule against us, and all signs point to the fact that that is quite likely. And then, when we appeal again to the Supreme Court, at that point it will be on the merits. A ruling at that point will be directly binding on the case itself, and we have a much better chance of getting Supreme Court review then.
Now, Hill goes on to talk about that Supreme Court review ultimately if it were to happen, and she says that they have some certainty that the U.S. Supreme Courts, with their Bruin decision, will find that certain types of bans on certain types of weapons is unconstitutional.
One thing is certain. The ban on commonly owned weapons protected by the Second Amendment are coming to an end very quickly. We know the Supreme Court is watching this issue closely. We know that they are interested, or they would have denied our emergency request immediately. And the issue of assault weapons bans will ultimately be decided by the Supreme Court. They will very soon be called upon to enforce their Bruin precedent on a nation full of lower courts determined to ignore both Bruin and the Second Amendment. So we keep fighting.
So that's Hannah Hill from the National Gun Rights Foundation, and the lead plaintiffs, along with Robert Beavis from Law Weapons, laying out their case as to how they respond to the miscellaneous order issued by the U.S. Supreme Court, saying that they are denying that motion for emergency injunction against Illinois' gun and magazine ban. So that's the big headline from yesterday. Somewhat unexpected as to the release of this order. But what's fascinating is the response to it. Not just, we heard from Hannah Hill and we heard a little bit from Robert Beavis there, but what about the chief sponsor of the Protect Illinois Communities Act? What did Robert Morgan, state representative out of Deerfield, have to say? We'll get to that next, and I'd love to hear your thoughts at 217-629-7970. Again, 217-629-7970. That's the phone number, live and local here with Springfield's Morning News on 92.7 WMAY, Springfield's News and Talk. All right. Talking about the U.S. Supreme Court's order in the National Association for Gun Rights versus Naperville, also Law Weapons Supply versus Naperville, says the application of writ of injunction pending appeal presented to Justice Barrett and by her referred to the court is denied. Nothing in there about the merits of the case, and I think that that's one thing that Hannah Hill from the National Association for Gun Rights made clear, is that this was just a temporary motion that was requested. It wasn't something that was going to be a permanent order on the merits. It was merely just saying, hey, these individuals in Naperville, Robert Beavis from Law Weapons, they are being irreparably harmed by not being able to exercise their Second Amendment, and that was presented to the court, but after the Seventh Circuit's consolidated cases and put it on a, quote, rocket docket with a hearing late June, after briefings back and forth, the U.S. Supreme Court saw that and decided to not proceed with a ruling in this case on an emergency basis. Could they still get it? Again, Hannah Hill from the National Association for Gun Rights saying yes, they could.
One thing is certain. The ban on commonly owned weapons protected by the Second Amendment are coming to an end very quickly. We know the Supreme Court is watching this issue closely. We know that they are interested, or they would have denied our emergency request immediately. And the issue of assault weapons bans will ultimately be decided by the Supreme Court. They will very soon be called upon to enforce their Bruin precedent on a nation full of lower courts determined to ignore both Bruin and the Second Amendment. So we keep fighting.
So again, this will eventually be decided by the U.S. Supreme Court, but when is that going to happen? So interesting to see some of the reaction out there to the order from yesterday. First, let's look at what Governor J.B. Pritzker had to say. On Twitter, he posted a statement saying, quote, "I'm pleased that the Supreme Court has ruled that the Protect Illinois Communities Act will stand as it continues to make its way through the judicial system. The gun lobby has insisted on every legal maneuver to block this law, refusing to acknowledge that lives will be saved by this important piece of legislation," Pritzker said. "Despite these challenges, I remain confident that the assault weapons ban will be upheld and will create a safer Illinois for our residents." Now, again, I'd love to get your thoughts on all of this at 217-629-7970. That's 217-629-7970. Let's get your calls on here early this morning. But you have another statement from State Representative Bob Morgan. He released a statement via his office, but also by email, and also on Twitter. And here's what Bob Morgan had to say. "Illinois assault weapons and high-capacity magazine ban is still in full effect. Justice Coney Barrett's decision reinforces," he says, "what we already knew, that the Protect Illinois Communities Act is designed, constitutional, and that it comports with legal precedent." Goes on to say, "This ruling comes from a member of the court's conservative majority without noted dissents, and the clearest indication yet of the strength of this life-saving law. Protect Illinois Communities Act has already prevented the sale of thousands of assault weapons in our state. This ruling's a victory," he says, "in the fight to keep these weapons of war from creating more carnage in communities like mine and countless others across the state." He then goes on to tag several gun control groups and others who want to see more gun control. But the comments on Twitter right after that, people bookmarking this for future memes, pointing out that Supreme Court didn't actually rule on the merits of this particular law. So, interesting to see some of the reaction here, because the Supreme Court didn't rule on the merits of the law. If you, again, look at the miscellaneous order, it's one sentence. It's not a full review of the merits. It's just one sentence saying that this emergency motion for an injunction is denied. That's why, while you've got the Seventh Circuit Court of Appeals with their consolidated cases pending on a, quote, rocket docket, a really fast review. So say we get to later this month and the Seventh Circuit Court of Appeals hears oral arguments. We don't know who's going to be on that panel. It's not going to be the same panel that consolidated the cases. Could be a totally different panel. So the outcome of the Seventh Circuit Court of Appeals decision on this after the hearing in late June, are we going to have to wait months? Because there's a separate case that deals with a Bruin challenge of a separate lawsuit out of Maryland, still in the Seventh Circuit. They heard oral arguments in the Seventh Circuit Court of Appeals, but it's been 6 months since they've taken the case and had oral arguments. So you gotta beg the question as to are we gonna have a definitive ruling from the nation's superior court before January 1st, when this law requires individuals to register their firearms? A ton of unanswered questions, but a lot of moving pieces as always. And we'll obviously bring you the latest here each and every weekday morning on WMAY. I'm Greg Bishop with Springfield's Morning News. I would love to hear your thoughts. You can always comment or email me, bishoponair@gmail.com, or follow me on Twitter. You can make that happen again. Just search everywhere for Bishop on Air.